So how can you keep your in-laws out of your estate? Hi, I'm Claire Langton-Yanowitz, attorney at the Yanowitz law firm, where we help clients with wills, trusts, and probate, and making sure people's property passes the way they want it to. Okay, let's get started. So a common theme when I meet with clients is keeping property, maybe out of their in-laws' estate. And I think people have a lot of different concerns in this realm for many different reasons. So sometimes it's just flat out they don't like their son, daughter-in-law, mother-in-law, father-in-law, whatever, granddaughter-in-law, and they don't really want them to have the money. Another focus that people have is they really want to have the property passed down the bloodlines. Maybe you inherited, the family farm or the cabin. You want to keep it descending down the family. You don't want to get it splintered off to the side. So that can be another reason. Maybe they think, maybe an in-law spends too much money, is not going to spend it on the right things. Sometimes people get concerned that maybe an in-law might get remarried in the future, and that property may go to their new spouse, and then it'll totally, be out of the family lines. Maybe that in-law has children from a previous relationship, and maybe, if the daughter-in-law were to get it, she maybe would leave property to her children at her death, and it wouldn't go back into the family line. So I hear those are all different concerns that sometimes people have with in-laws. And another thing that people have is they get afraid that they're going to leave it with their child, and then maybe down the line their child might get a divorce, and all of a sudden maybe their son-in-law is going to be trying to grab at some of the inheritance as part of the divorce proceeding, and so that can be a big concern. Okay, so there are a couple of different ways to leave property to children. One is outright, and the other one is in trust. And we're going to talk about kind of the pros and cons of some of those as it relates to in-laws. So with an outright inheritance, there is kind of the danger that, when you pass away, you leave money to your daughter, that she might commingle that property with her husband. Okay. And so maybe when they get divorced, she might not know what she inherited. It's been commingled for a long time. And so, he might walk away with some of that inheritance. So there's that issue. Also, if she inherits outright, let's say she inherits $500,000 at the time of death, but the property appreciates, so it's worth $600,000 later on when they get divorced. If she inherits outright, that appreciation, that $100,000, most of the time, if they haven't signed a premarital agreement or postnuptial agreement, will become subject to the divorce proceeding. So maybe not the full $500,000 if she has kept it in a separate account will be subject to the divorce proceeding, but the appreciation on those assets can be subject to a divorce proceeding. So that's an issue. Also, if she inherits it outright, maybe she's going to have a bunch of pressure to commingle it with her, or to spend it in certain ways, and since it's her name, she's just gonna do what her husband says, and that's that. So a second option that people sometimes consider when they're concerned about maybe their kid's going to get divorced in the future, and they don't want to have like an ex-son-in-law or an ex-daughter-in-law grabbing at these assets, is they might give it to their child in a trust for their lifetime, okay? And this can be beneficial because if they later get divorced, in that scenario before where, the the inheritance appreciated from 500 to 600, that appreciation, if all the assets stay in the trust, then that appreciation on the inheritance, that $100,000, is not likely to become part of a divorce proceeding. Now, it can be a factor of where they're getting divorced, but at least in Minnesota, it's less likely to become part of a divorce proceeding if the assets are inherited in trust and they stay in the trust, okay? Now, another fancy thing you can do with trusts is you can make sure that when your child dies, the assets pass in a certain way. So sometimes I think in society, people will call this the reaching from the grave, where you say, well, my child is going to have it for their lifetime, but at their death, it's going to go to the grandchildren of that child. It doesn't pass over to the spouse of my child, okay? So that is something else you can do with lifetime trust. You can control where it passes when someone dies, okay? And so that's something to consider. Now you can give your kid something that's called a power of appointment, where with a power of appointment, they're able to kind of change where it will pass at their death. So you can give your child the ability to pass it to their spouse at their death if they exercise the power of appointment, if they sign a legal document saying, at my death, my trust goes to my husband, okay? So they have the ability to, if they take action, they can give their trust to their husband at death. But if they don't take any action, they don't sign a legal document, then it goes to the kids. So you can leave the decision with your child to give it to their spouse. But if they don't exercise it, the default is that the spouse won't inherit at the time of your child's death. So that is a popular thing that we do with these types of trusts. Now, something to consider if your child is inheriting in trust is who is going to be the trustee of that trust. Now, if your child is the trustee of that trust, that might be convenient and low cost. Your child's not going to charge itself for acting as trustee. Now, in some states, it's really important to require a co-trustee or to have an independent trustee serving. So that means, someone who's not inheriting under the trust, who's not an employee of your child, an independent person, bank, institution, being trustee. Sometimes, you must, like in states like New York, I've heard that in New York, it's very important that you have a co-trustee that's independent, or some trustee that's independent serving at all times. So with that being said, it can also be helpful sometimes to have someone other than your child as trustee if maybe your child is married to someone who's going to put a lot of pressure on them to take all the assets out of the trust and spend it on ways that you don't think should be spent. It's better not to have your child be better not to have your child be trustee, or to have someone else be co-trustee with your child, so that doesn't happen. So thank you so much for listening in today. If you have any questions, feel free to contact our firm. And if you found this video helpful, feel free to pass it along to someone who might enjoy it. Thank you.